Hello viewers, welcome to the Editorial Analysis by Drishti IAS. In this section, we regularly take editorials from various newspapers and news portals for a better understanding of various issues happening in India and around the globe. In this section, we first try to link the editorial with our UPSC syllabus, then we go analytical in order to understand some key points and at last some important concepts. Dear viewers, we truly hope that you like this initiative taken by Drishti IAS and your feedbacks are important for us, so kindly feel free to give your important feedbacks in the comment section. So without any further delay, let's commence our session.
Dear viewer, this video is available in Hindi as well. If you wish to watch it, please visit our Hindi YouTube channel, Drishti IAS. For your convenience, the link for this video in Hindi has been provided in the description below.
Today's editorial is taken from the Financial Express published on 19th of November 2020. The title of today's editorial is Justice Can't Be Selective. If we try to summarize today's editorial, we can say that Chief Justice of India S.A. Bobde is both right and wrong on Article 32. If we try to link today's editorial with our UPSC syllabus, we can link it with sections that include polity, governance, constitution, international relations, etc. Some key points from today's editorial. Now, the Chief Justice of India, S.A. Bobde, while he was hearing of a plea for the release of a Malayali journalist whose name is Siddiqui Kappan, along with two other Justice A.S. Bopanna and V. Subramanian, they have raised a question to the lawyers of Siddiqui Kappan. They have asked the lawyers that why the lawyers did not approach the High Court for bail first and rather they approached Supreme Court under Article 32. If we talk about Article 32, it is the fundamental right to constitutional remedies as well. It protects the rights of a person to approach the constitutional courts like the Supreme Court and various high courts against the violation of any of the fundamental rights. Hardly surprising, at the time of the framing of the Constitution, Dr. B.R. Ambedkar termed this article as the heart and soul of the Indian Constitution. Now, recently, the Chief Justice of India, S.A. Bobde, during the hearing of a plea, he has said that the court is actually trying to discourage the petitions filed under Article 32. Now, if we talk about some important key points, it can be said that the opinion of the CGI noted that there is a spate of Article 32 petitions and reiterated that the High Court can also uphold fundamental rights under Article 226. If we talk about Article 32 of the Constitution, now what exactly it is, what exactly it does, so it is important to understand that. Like I said, Article 32 of the Indian Constitution is also known as the right to constitutional remedies. It is a fundamental right which states that individuals have the right to approach the Supreme Court seeking enforcement of other fundamental rights recognized by the Constitution. The Supreme Court has power to issue directions, orders, or you can say writs for the enforcement of any of the fundamental right. The writs which are issued, they are named as habeas corpus. The second one is mandamus. The third one is prohibition. The fourth one is certiorari. And the last one is quo warranto. Now, these are the 5 writs which are issued by the Supreme Court under Article 32, quo warranto. Okay. Now, the right to move to the Supreme Court shall not be suspended except as otherwise provided by the Constitution. Thus, the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental right during a national emergency, Article 359. Okay. In case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original, but it is not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. So it is important for us to understand what exactly Article 226 is. So the Article 226 of the Constitution empowers a High Court to issue writs, including habeas corpus, mandamus, certiorari, prohibition, and quo warranto, for the enforcement of the fundamental rights of the citizen and for any other purpose. Now, the phrase that I have used, for any other purpose, okay, important to understand, for any other purpose, it refers to the enforcement of an ordinary legal right. This implies that writ jurisdiction of the High Court is wider than that of the Supreme Court. This is because the Supreme Court can issue writs only for the enforcement of the fundamental right and not for any other purpose. That is, it does not extend to a case where the breach of an ordinary legal right is alleged. Now, the High Court can issue writs to any person, authority, and government, not only within its territorial jurisdiction, but also outside its territorial jurisdiction, if the cause of action arises within its territorial jurisdiction. Okay, so this is something quite important for us to understand. Now, let's move ahead. The CGI statement that the Supreme Court was trying to discourage Article 32 petitions was correct to the extent that if all petitioners appeal to Supreme Court before approaching the High Court, Supreme Court will have little time to deal with other matters. Now, when CGI gave the statement that they were actually trying to discourage the petitions filed under Article 32, it was quite correct to an extent, because if all the petitioners they start appealing to the Supreme Court before approaching the High Courts, then Supreme Court will be flooded with all such matters and will have very less time in dealing with other matters. That said, Supreme Court needs to keep in mind that while lower court should be petitioned first, there is a big pendency that delays matter, and to the extent this means matter gets delayed, this delays justice for those accused of a crime. However, Supreme Court also has to think that the lower courts, when they say the lower court should be petitioned first, it should be noted that there are already lots and lots of matter that are pending there, and in such a situation the matter get delayed, and also the justice for those who are accused in a crime, it also gets delayed. Now, if we talk about the present scenario, there are more than 4.1 crore matter pending at the lower courts and high courts, while the Supreme Court has 63,000 pending cases. Over 4.1 crore matters are pending in the lower courts and high courts, whereas 63,000 matters are pending in the Supreme Court. As this newspaper, that is the Financial Express, has pointed out earlier, the high number of pending cases exacerbated by the pandemic and the various restrictions on the normal functioning of the court can be attributed to the chronic inadequacy of judiciary strength. Now, because we saw the pandemic this year and several other restrictions on the normal functioning of the courts can also be attributed to the inadequacy of the judiciary strength. Apart from slow uptake of technological solution, much of which were announced under the e-court mission mode program of the National E-Governance Plan, against a sanctioned strength of 1,079 judges, the High Court have 673 judges, while similarly significant shortfall plagues the lower judiciary as well. There are several technological solutions that have been adapted, however they are not adequate. Also, a total sanctioned strength for the number of judges in High Court is said to be around 1,079, whereas as of today there are only 673 judges in the High Court. And similar shortfall is also observed in the lower judiciary as well. No wonder then nearly a fifth of the cases pending in the lower court have been in the balance for over 5 years, and this is the reason why the situation is so bad. The way ahead. This has resulted in our Kapan remaining jailed for months. He has been in prison since October 5 under the Unlawful Activities Prevention Act that likely has the most draconian incarceration provisions that can be invoked under the Indian law. Because of such an issue, because of such delays in the lower court and the high courts, because of such issues, we can say that Kapan has been in jail for almost 2 months. He has been in the prison since October 5 and he's booked under UAPA, that is Unlawful Activities Prevention Act, that can be said as one of the most draconian laws under the present Indian law system. Indeed, there are many prominent citizens, such as lawyer Sudha Bhardwaj, for instance, and ordinary ones languishing in jail as the due process translates into an undue delay. Not only Kapan, but there are several other prominent citizens who are actually in the jail for such reasons. Also, the Supreme Court can't be selective about the application of Article 32. It heard the public TV's Arnab Goswami's plea under the same article. Through it, it is true that Goswami approached the High Court first. Now, if we look at this situation, we can say that the Supreme Court cannot be selective with reference to the cases that are coming under Article 32. Supreme Court cannot have this idea that they will pick one particular case under Article 32 and on the other case they will give this idea that the case should be taken to the High Court first. No. The same example is quoted by many people that if such is the case, such is the situation, then why the Supreme Court heard Arnab Goswami's case which was also under the same Article 32. The Supreme Court heard it and gave bail to Arnab Goswami. It should not be forgotten by the people that Arnab Goswami came to Supreme Court only after when his plea for bail got rejected in the High Court. So he followed a particular channel, it can be said in this very case. No matter how exasperated the CJI was with the spate of Article 32 representation, he has to keep in mind that the only situation in which the rights flowing from Article 32 ceases if there is an emergency or the Constitution is itself amended to allow this. See, no matter how exasperated the Chief Justice of India was with the spate of Article 32 representation, this situation can only change if there is an emergency or the Constitution is itself amended in order to allow such a situation. So viewers, this was with your today's editorial analysis. Now, the question that can be framed from today's editorial, it could be why the Article 32 has been called as an article without which the Constitution would be nullity. Discuss how writ jurisdiction of the Supreme Court differs from that of a High Court. So, viewers, this was with your today's editorial analysis. I hope you liked it. Thank you very much.